me ready to go for today's training. I'm very excited to be here. I've done a number of these chapter chats with the NASW New York State chapter, and it's always a very good experience. I am an attorney. I have been one for over 16 years. I previously worked at a nonprofit law firm where we provided free legal services to individuals who could not afford attorneys. My practice initially was set up to help individuals living with HIV. That turned into a wider LGBTQ focused practice with a significant overlap of people who had mental health concerns. I did a medical legal partnership at the Callan-Lord Community Health Center for like 8 years, where I worked very closely with their mental health department and care coordination teams. So I got to see a lot of the firsthand work of mental health professionals, which was great. I also switched gears in 2018 to help self-employed people and small business owners. And in 2021 went into private practice with an idea to help mental health professionals and artists, designers, and creatives. As time has gone on, most of my time is spent on mental health professionals. I'm sort of moving away from the creative clients at the moment, although I still love them. They're great. And yeah, so I provide a lot of the same services for you all. And with that, I kind of have a flat fee schedule for a lot of the big projects that I do. I also help people with sort of more urgent issues, let's say like client terminations or requests for medical records or private health information. So when those things come up, I usually charge an hourly rate. If anyone's interested, you should feel free to reach out to me for more information about my rates and services, and I'll put in my email in the chat now. The training that we're going to do today, so you want to start a private practice, I'm going to work off of my guide that's on my website, which I would provide the link for. And just having a here. Let's see. Here we go. I'll open a few other pages on my website as well with different guides. One that's really specific to starting a PLLC, another one about telehealth, and possibly some others depending on how things go and what kind of questions are coming up for people. So again, like Katie said, feel free to ask questions in the chat. I'm going to do my best to keep an eye on them as things go on. And yeah, we will start now. I should also say that I'm not providing any legal advice today. This is an informative session. So if there are specific questions, I'm answering generally, and there are some things, that I might not be able to answer, whether it's because it's so specific or it's just outside the scope of what I do. All right. So to start, I know a lot of you are thinking of, I'm sorry, I can't get rid of that line right now. I'm not seeing where it's coming up. How I erase it. Sorry. All right. So a lot of people here are starting to think about forming a private practice. And a really good first step in doing that is writing a business plan. I really recommend it for everybody to start thinking about what your goals are in the short term and the long term, thinking about what your overhead costs are going to be, how much money you need at the start to get things going, and help you decide what fees to charge, how many clients to have, whether you need office space, if you're going to operate primarily remotely, and those sort of things. So I provided a template from score.org, which is through the New York Public Library, as a good starting point for you there. I know there were some questions in the chat already about the different business entity options that people have. And you've probably heard a few of these names being floated around. Usually the most common ones are PLLCs and PCs, professional limited liability companies, and professional corporations. There's also sole proprietors and sole proprietorships, I should say, and a few other entities. We're going to focus mostly on PLLCs and PCs for today, since those are the most common. As you might know, you can operate as a sole proprietor, which means that you do not open your own entity. The reason that people usually start their own entity is to protect their personal assets from liability issues. And, it can be complicated in your industry because limited liability protection does not work for malpractice issues, but that's what malpractice insurance is for. So your limited liability protection usually works with like other contracts that you might have or other things that might come up, let's say around like leasing commercial space or having employees. Those are usually two of the bigger things that might come up to cause disputes for people. You can learn a bit more too about the regulations on what business entity types you can have in this other guide that I have here that's called Select Mental Health Business Regulations. I'm going to put the guide that we're working off of today in the chat again for the new people who have joined. But yeah, just really quickly to speak a little bit about professional limited liability companies and PCs. I do have a guide to forming your own PLLC on my website here, and you can check that out and follow it. There are some bumps in the road along the way, which makes it really complicated. I help, there's others who provide services to help people get them formed. And we start usually with a PLLC because it's a bit simpler than other entity forms. Usually with like a professional corporation, there's more regulation around it. There's more formalities for you to follow. And there's other issues with your tax liabilities. People might want to consider talking to an accountant at an early stage to help them see how the different entity types are going to affect their tax status and their tax liabilities. So one of the things for professional limited liability company is that there's pass-through taxation. So instead of being taxed at the business level and then again for the profits that you receive from the business, it's passed through. You're only taxed once. With a professional corporation, in theory, you're taxed at the corporate level and then taxed again as an individual. But there are other ways to change that. One of them is by filing as an S corporation, which also is available to people who have PLLCs. There's often confusion about S corps and whether that is its own separate entity from a PLLC and a PC. An S corp is actually just a filing designation with the IRS. So those are things to keep in mind there. Again, you can find, I'll post this to my guide to forming your own PLLC. I'll check this out. Someone has a question about if we don't have an office or employees and are only doing virtual practice a few days a week from our home, does it make sense to get a PLLC? This is a big question that comes a lot. I think there are other risks involved in, operating your own practice. I don't think that the risks tend to be huge for what you do. And it is really hard to make like a blanket answer for people. It kind of can depend on, your individual plans and procedures. So I think it can help to get individual advice on that issue. But generally speaking, I think, if people are starting this and they're sort of planning to do it through retirement, it can be really good to establish it early on to set yourself up to have this protection as you move forward through the life of your practice. There are quite a few issues too when you're forming your business entity, whether it is a PLLC or a PC. I really encourage people to check out the rules and regulations that are on the Office of Professions website. I have links to them here. There's a lot of rules around how the name that you choose, And the Office of Professions can be really helpful in helping you navigate what names to pick. I absolutely recommend that you run your names by them before you file everything. Otherwise, you may be waiting a while only to hear that your name didn't go through. So, as some people may realize, the first step here in the process of forming a PLLC or a PC is to request a certificate of authority from the Office of Professions. You can see that I have here information about how to make the request. You can go to the Office of Professions website and they lay out what forms to fill out, including the articles of organization, which ultimately get filed with the Department of Corporations, and 2 other forms that the Office of Professions requires for them to issue the certificate of authority. Once you have the certificate of authority, you file your articles of organization with the Department of Corporations. Right now, the wait time is 3 to 4 months. Just last year, it was like 8 to 10 weeks. I think everyone, including the Office of Professions, is really hopeful that they're able to get back down to 8 to 10 weeks at some point soon. So we'll see. But right now, people really need to factor that into their plans. And, depending on when you really wanted to launch the business entity, you might want to move a little bit quicker on that first step. Again, once you have the certificate of authority, you can file the articles of organization with the Office of Professions and the necessary forms that go to the Department of Corporations. You should consider requesting expedited handling and also making the request by fax so you get more immediate results. With expedited handling, it's just $25 for it to be processed, I believe within 24 hours, they say. After the entity is formed with the Department of Corporations, you complete registration by sending a certified copy to the Office of Professions. Some of you may know that with a PLLC in New York, you're required to file, to publish notice of the creation of your business entity in 2 newspapers. You start by contacting your county clerk to find out what newspapers to do it in. And those ads run for 6 weeks. At the end of that time, you file a certificate of publication with the Department of Corporations. At that point, the business entity, in terms of filing things with these government agencies, is complete. You also have some other things that you're going to do to form your business. At that point, once things are filed with the Department of Corporations and it goes through and you get a filing receipt, the certified copy, you're able to practice under the business name. But there are still some other things for you to take care of. One of those is to draft an operating agreement, which is essentially like the blueprint to your business and how operations are going to run. Generally speaking, with a solo PLLC, where it's just one person, the operating agreement isn't like hugely important. Like the details of it, you absolutely have to have it. It's an essential component to forming the business. But it's not as complicated as if you have multiple members. When you have multiple members, you really want to like hash out how decisions are going to be made. If the business needs more money put in, more capital, how you're going to do capital calls, how money will be distributed to all of the owners. Those sort of things are really important to hash out early on and be really thoughtful about and make really clear guidance for yourselves in the operating agreement to really help, lower the risk of having problems come up down the road. You have some obligations again once the business is up and running. I have a guide on my website that runs through some of the basic legal maintenance issues for maintaining your entity. So you can check that out. And yeah, you can also consult an attorney to talk about like the specifics about your business, but that's roughly the overview of the big things for forming the PLLC. Once the business entity is formed too, you'll set up an EIN. You should get an NPI for the business entity separate from your own NPI, because you really want to do business in the name of the business as much as possible, as a way of reducing your risk of liability issues, personal liability issues. Does anybody have questions about the PLLC formation process while I try and figure out how to erase this yellow line? That's never happened to me before. All right. So going back to my guide here, which for the sake of it, I'm just going to put in the chat one more time for anybody new who's joined. And yeah, we're going to talk a little bit about some of the important business documents that you need, or practice documents rather, from the start of your business. And some of you may realize some of the essentials that are required by law. Others are really just like a best practice issues. So certainly having client policies and procedures as a starting point to really lay out how things work with your practice. So for instance, talking about, how best to contact you, how to contact you generally, whether you use email or, you want all communications to go through your EMR, if it's simple practice or something else, whether you accept text messages. Best way to contact you is a good starting point. Talking to people about how billing and payment issues work, whether you accept insurance, whether you, have people who do not accept it, or who don't pay with insurance but need super bills. A lot of things like that can be worked out early on, so people really have a clear understanding of how they're going in. You should really also consider how you handle cancellations and client terminations. Those are two big things that I think are really important for your policies and procedures, because if you run into those issues down the road, you can, point to the policies and procedures and remind people that whether you discussed it, hopefully you discuss these issues too early on in the relationship, you can, remind them how things are handled when it comes up. Let's see, there's a silly question. So yeah, okay. The question is, if we are just practicing on our own, renting office or virtual, is this considered starting a business? I would consider that starting a business. You're operating, it sounds like you would be operating as a sole proprietor if you haven't set up a separate business entity. That is still operating your own practice and therefore your own business. The steps that I mentioned before about forming a PLLC, it's not required. You can operate as a sole proprietor. I think there are really valuable reasons to setting up a PLLC. Obviously, the most fundamental is that you are protecting your personal assets from personal liability. It's really, the idea is to create a shield. So if there's conflict, that conflict is between the other party in the business entity and not you as an individual. Okay, I see someone told me that I have to stop share and reshare to get rid of the line. So we're living with the line, which I feel like most of you are not even noticing, but it's just staring me right in the face. And I'm going to move on from that. Thank you to that person. Another question that I got is, are operating agreements required in New York State? And yes, they are. And that is part of the LLC and PLLC formation process. That actually is an issue I should have hit before too. There's so much confusion, and this really just frustrates me so bad that it's not more clear. Really on the Department of Corporations websites too, but a lot of people form an LLC instead of a PLLC. You cannot practice your profession under an LLC. When you form a business entity, it has to be a professional limited liability company, a PC, an LLP, the other professional business entities. So it's very important that people keep that in mind. Okay, so moving on to the other client documents, informed consent for video conference sessions is quite important, especially as things get much more complex in 2024. I know a lot of people were aware of the recent hack of one of the systems. So really letting people know what technology you're using and helping them understand what the pros and cons are. Really big cons would be the possibility of a third party accessing their information. So letting people know that and putting it in writing is really a big deal at this point. Under HIPAA and New York state law, you provide people with a notice of privacy practices. Keep in mind too that you might have privacy practices that are specific to your website. Notice of privacy practices here that I'm talking about are really about your practices for the practice itself and for you engaging with your clients and how you protect their information, how you manage when there's requests for disclosures, if there are situations where you're legally required to disclose information about them, their protected health information, and running through those scenarios with them. So you provide a notice of privacy practices for people, and then you also establish with them these scenarios so they know. You post it on your website as well as required by law. Okay, while I answer this next question, which is a bit of a doozy, we're going to come up to it. Actually, I'm going to hold off on that. Someone asked about 1099, so we're going to hit that in a little bit. But let me do a quick stop share and then reshare. People are okay with that. All right. Thank you for that advice. Okay, so the next document that is really essential to your private practice is a good faith estimate. I think a lot of people know that Congress passed the No Surprises Act now 2 years ago, requiring providers to give their clients a good faith estimate. The good faith estimate, which is discussed in more detail in my guide, is to let people know what the expected charges are going to be for them. People are supposed to receive it before services start. They're supposed to receive it before any new charges are added. So it's really important that people do that. The idea is that it's for people who are not paying with insurance, although it does seem like there's going to be a requirement coming up soon for insurance paying clients as well. Next, we have other documents that are really related to, releasing information. I mostly refer people to one of the New York State forms, which I think is good and, really lays things out. I'll pull it up too as we're talking in case anyone's interested. Say it's DOH 5032. Forms. Yeah, it's DOH 5032. I think that's a good, strong form, gives you consents. You should also be aware of the extra protections that people have around release of medical information, release of HIV-related information, and then also around drug and alcohol treatment. Okay. I'm just going to put that link in the chat for people who are interested. There we go. As I discussed before, website notices in terms of conditions are really important. I will just make general statements too here for people's own thinking. I think people should be cautious about what information they gather on their website. The more information that you're collecting from people, the higher degree of care that you have to give with protecting that information. That makes me a bit nervous because you may be dealing with people who aren't yet clients and you may not know what they're going to end up providing you. And it might create other responsibilities for you in terms of protecting it. So generally, I like people to limit the information that they're collecting on their website. But again, everyone's situation might be different. And this is definitely an area where it's important to talk to a lawyer, somebody else with that experience to really understand what you can be doing and what other responsibilities you're going to have depending on the information that you're collecting. Okay. I see another question in the chat, and we're gonna go over that a little bit. I group email into telehealth. So give me a moment on that, and if I haven't answered your question once we hit it, feel free to remind me. Make sure I actually do. So this speaks to, now we're going to talk about hiring employees and independent contractors. I'm skipping over a little bit as we're going into employees here on essential practice documents. So this is a big issue. I know the common practice or a common practice for a lot of people and what people are used to in the industry is that your relationship, potentially if you're, working with a practice, is as an independent contractor or a 1099, as someone said in the chat. And you really have to be careful about who is an independent contractor. If I was going to boil it down to one sentence, I would say that if somebody is doing the essential activities of a business, they really are properly classified as an employee. An independent contractor really is more someone who has a very discrete role. They operate independently of the business entity. They're free to work with other people. They run their own schedule. You're not supervising them. You're not really managing everything they do. You give them a discrete task. The example that I like to give is someone who is creating your website for you. You're giving them a task, they're coming in, they're getting the job done, and then they're out. If somebody is there and they're working regularly, they're there a few days a week, they're seeing clients, they're providing psychotherapy, I would argue that that person under New York state law, with the IRS, with the Department of Labor, with the Workers' Comp Board, those people really are probably properly classified as employees. And you run the risk if you're bringing therapists into your private practice and treating them as an independent contractor, that one of those agencies is going to come and take issue with you. There may also be issues with the individual themselves and their ability to make claims against you for lost wages, benefits, and other things. So I really, really encourage people to think about that and how they're moving forward. There is some indication that some of those agencies are more aware of what's happening in this industry and are looking at it with more scrutiny. So consider that the core essence of your business is very likely to provide psychotherapy services. If you're hiring people to do that, it's very likely that they should be classified as an employee. I would say that they should be classified as an employee. If you are going to be an employer, I'm sorry, I also have a guide on my website that helps you distinguish between independent contractors and employees, though I basically just gave my boiled down version of that guide. Next, I want to talk about some of your responsibilities if you are moving in the direction of being an employer. And I have a guide on my website too, which is here, I want to say, nope, on responsibilities of New York employers. And I run through a whole lot of things here. Again, this evaluation of an employee versus an independent contractor, wages and benefits, dealing with interns, taxes, other benefits that people might be entitled to. Very unlikely for people to be required to provide health insurance, as the law requires only employers with 50 or more full-time employees to provide it. Safe and sick leave, rather, is a big one for people to consider. Written here is sick and safe leave, where you're required to provide unpaid safe and sick leave to your employees if you have 4 or less, or you're making less than $1 million, the practice as a whole. If you have 5 or more employees, or you're making more than $1 million, you are required to provide up to 40 hours a year of paid sick leave, which can accrue on a 1 hour for every 30 hours worked basis. Highlight that it's important for people to also receive a policy that lays out how safe and sick leave works. You're required by law to provide it. Paid family leave. You can think about retirement plans. Paid family leave is required. Retirement plans are not, but that could be a good incentive. And then I have some guides here too on some cost-efficient ways in theory to do that. You have to be aware of the notices that you have to provide for employees, let's say around sexual harassment and discrimination and other issues. So check that out. I talk about health unemployment insurance, which is also required in that same grouping of paid family leave, workers' comp insurance, and short-term disability insurance. So check that out as well and consider that as you're moving forward. There's other legal requirements when you're an employer. You can check this out here at the end. Does anybody have any questions or thoughts about being an employer before I move on? Okay. So supervision is a big issue that comes up a lot. And tomorrow there's going to be a session, a chat related to LMSWs and their scope of practice. There's often a lot of confusion around how LMSWs can be supervised. It's very important that they are in a practice or in a facility or setting that is allowed to provide supervision and to practice clinical work. So an LMSW in their own practice can't hire someone outside to supervise them. They have to be employed in a facility that is allowed to do it. And Katie, thank you. You just posted the link to registration for that. So there is an interesting question going back to the employee independent contractor issue around if there's a concrete number of hours to consider that. That's really not how it works. Someone could work very few hours and still be considered an employee because of the activities that they're engaged in, the relationship with the employer, whether someone's managing how they work. There's a lot of different factors there. I didn't mention it earlier too, but direction and control is kind of a shorthand way of considering how New York State distinguishes between employees and independent contractors. So the level of direction and control that the hiring party has over the hired party is a big consideration. So think less about the amount of time and more about the relationship and the activities being performed. Okay. I think we're good on supervision. Thinking about liability issues, New York State lays out the regulations for what activities you're able to do in your profession. So here we're mostly focused on social workers, but of course, all the different professions, mental health professions have their own regulation and lay out exactly what that scope is. And there are issues that come up with people. There's disciplinary hearings over people leaving the scope of their practice, potentially engaging in work that requires a different licensure, or operating with like a dual relationship with clients, maybe providing services that are really outside the scope of this profession. So I encourage people to get familiar with the regulations around their specific profession. The Office of Professions has established professional standards of care, which is a really useful place to consider, the boundaries of the practice and to think about the unprofessional conduct, what constitutes it, and where you may be crossing lines or having boundary issues, let's say, with clients. Each of the professions has its own ethics guidance, which I'm sure many of you have considered and thought a lot about, but just for the sake of bringing it up, there's some links there. So privacy, confidentiality, security, and disclosures, these are big issues that come up with you all. And, the sooner that you start establishing proper procedures, the better. You are required to do so under HIPAA. I did a training for the NASW New York State in the winter around telehealth rules and best practices. So I encourage you to check that out as a potential starting point. As I mentioned in this website, there is a great organization called Person-Centered Tech, and I highly recommend people check out their extremely useful resources on their website and the services that they provide to help people establish procedures and rules and think about, what platforms they're using to communicate with clients, to keep client protected health information protected. Really, really great organization that is focused on that specifically, hugely helpful. Let me just go back to this question. So there was a question about best policies in situations like using email. At the end of my guide to telehealth, obviously you should read the whole thing because I put so much time into it. But at the very end, I'm just going to scroll to the bottom here. I feel like I'm going to miss it. And I do have a section on best practices. This one is definitely one of my longer guides. Let's see. Yeah, so best practices here, thinking about the software that you use, performing risk analysis, implementing reasonable and appropriate security measures, documenting and maintaining policies and procedures. I do get there's some generalizations here. Person-Centered Tech really does help you get into the nitty-gritty of a lot of the things as well. But I think there are ways for you to make your practice operate in a reasonable way with still being compliant with HIPAA. HIPAA really does lay out specifics that you have to do, informing your clients, making sure that they know what technology you're using, how you're protecting their information, getting BAAs, which are business associate agreements, from the providers that you're working with, whether it's for your phone, your email, or like your EMR. It's very important to have that. The BAAs should lay out that those third parties are following HIPAA 2 and doing what they need to do to follow your own policies and procedures around protecting clients' private health information. So please do check that out. And again, Person-Centered Tech is really good advice about which platforms to use and establishing great policies and procedures. Making sure that you have a strong notice of privacy practices that's really clear can also be a huge component to that. I will just say too, I see that you're worried about, even if you are using a HIPAA protected platform, feeling uncertain about what that really means. There's other like outside measures for you to take, right? That you're using devices that are password protected, that your clients are too, that your clients know how things work. I generally like to advise people not to communicate with people about protected health information electronically through electronic message. I think, as much as you can to limit it more to communicating about sort of logistic issues like scheduling and rescheduling cancellations would be what I consider best practice, and leaving protected health information for sessions and discussions with clients. If there is something that needs to be sent to a client electronically or from a client electronically, there's additional measures that you can take, like encrypted messages, which also aren't, a surefire guarantee of protection. But one, really trying to limit what gets communicated, having your own level of control about what you're receiving from clients, and like how much of an extra record you're creating for someone that you have to protect, because you do have to consider that all of those messages between you and a client are a part of the record and part of your duty to protect and maintain, have accessible if there's requests from the client or potentially other requests for disclosure. And yeah, also just communicating to clients about those risks that are involved with the different technologies and making sure that they understand what they're getting into. Even if it's not part of your practice to use encrypted messages because you're not communicating with clients regularly like that. Let's say an emergency comes up and you need to receive something from someone, getting informed consent from them to use that specific technology in that one moment is an important practice. I don't know if anyone has any other questions around those issues, let me know. We talked about the notice of privacy practices. Another big issue that comes up is around practicing across state lines. It gets very complicated, as I think probably most, if not all of you already realize, with licensure that is specific to a state. Generally speaking, if you or the client are out of state, I recommend that you check with the rules of that other state in terms of what you're able to do. New York's own rules, which I talk about here, essentially say, well, actually, I'll read it verbatim for the sake of it, but here it says, in New York State, this is from the Office of Professions website, a practitioner must hold a New York license or be otherwise authorized to practice when providing professional services to a patient located in New York or when the practitioner is located in New York. So if your patient is in New York and you are somewhere else, you should have licensure in New York. You also should check with the state that you're in to see if you're able to practice there. If you are in New York, and your client who seemingly regularly resides in New York, because that is how you were introduced to them and how they came to your practice in the first place. Let's say they're going on vacation or something like that. You check with that other state to see what their requirements are. Some states have limited permits that you might be able to get. Some states have, easy registration processes that allow for telehealth in their state. You can check out Arizona, Vermont, Florida, another state that I'm spacing on right now that have eased their telehealth restrictions. So with like a simple registration, you might be able to provide telehealth services to individuals who are located in the state. But it's just very important for you to consider following not only New York's rules, but considering the rules and regulations of the other state. There is a question that says, are there audits of private practices done by state entities? If so, what are some of the things they are looking for? That's a good question. I can't say offhand. I don't have my own experience with people. It sort of sounds like kind of randomly being audited. But I think where it might come up is if there is a complaint or otherwise a practice is drawn to the attention of, let's say, the Office of Professions in New York or whatever that governing body happens to be in another state, where they might scrutinize the practices that the practice is performing, checking out the website, thinking about the name, what information is being put out there, potentially doing an audit and an investigation as well. So it hasn't come before me, but I think there is definitely potential for it. I don't know if anybody else here has had that experience or knows that answer, but please chime in if you do. Someone just asked if I have a website or tool guide on the out-of-state information that you just mentioned so we can check. So I don't have a guide that speaks to every state, but actually, because I am like the biggest fan of person-centered tech, I have to drop their name as much as possible. On my website, I do have their due diligence worksheet, which I really like, that helps people figure out how things work with this interstate practice. Again, the guide that I'm working off of right now, I'm going to put in the chat again for anyone who hasn't seen that link. But otherwise it does get really complicated. We're talking about 50 states that potentially a lot of them really do have varied regulations. So I encourage people to check in and try and stay on top of it as much as possible. For the most part, I will just say that states are looking out for their residents, and that is really their biggest concern. So if someone is certainly living in that other state and someone's practicing across state lines, providing services without being licensed in that state, that is like the number one thing that they're worried about. And then there's a variety of different ways that the different states handle these other issues. But keep that in mind. They're trying to protect their residents, and to whatever extent it might be, people who are located physically in their state at the time of this service that you're providing. Okay, so yeah, more information also on just practicing state lines in my guide. I'm skipping through it. We have about 10 more minutes. So if people have other questions that they want to get to, please drop them in the chat now so I can try and hit everything. I have a little bit on in-person operations and considerations there, a little bit on malpractice and other insurances that people might want to consider. I know the NASW partners with a malpractice provider. It might be specifically through the NASW. I'm forgetting that offhand. But that could be a good starting point. We talked a bit about good faith estimates, preparing for personal. Thank you, Katie. Preparing for personal emergencies is a big issue and thing that people really need to consider. Creating a professional will. And I did a presentation, a CE, I want to say that was in February, on preparing for personal emergencies. So I have a guide here on my website to it. And one thing that I really just want to hit home on for people is that your requirements, your responsibilities in terms of client records go on beyond your death or incapacitation. So it is very important that you create procedures for someone handling that in case of an emergency for you. So appointing a professional executor is really a straightforward way of starting that and giving them clear information and instructions on how to handle the records, how to access them, also alerting your clients to, you know, what happens if this situation presents itself. Okay, someone asked a question about receiving and sending info by fax, safe, or to do regarding protected health information. That is complicated. You know, I believe actually under HIPAA 2, it is considered a telehealth method. So there are these same issues that come up. There may be issues around interception around it. It's not something that really comes up for me a lot. So I'm sorry, I don't really have very concrete information about it. I would say person-centered tech is a good place for information about that. Management service organizations people maybe have encountered. There are quite a few out there, and people really have to be cognizant of the laws and regulations in New York around things like management service organizations. New York has a prohibition against the corporate practice of medicine, where some of these MSOs really come into the danger zone in terms of the corporate practice. So the idea essentially is for a management service organization that they can provide like back of house admin support. So potentially around like helping scheduling and billing and things like that. But there are a lot of rules about like what they're able to dictate, what they're able to tell you to do. The whole fundamental idea of the corporate practice of medicine is you have this licensure, and someone without that license should not be directing your decisions in your business. Their decisions may be based on profit and finances, where for you, the best interest of your clients is really the guiding principle there. And from there, making decisions that take that into consideration. So I encourage people to be mindful if they're going down that road. Fee splitting comes up with this too. New York has a bar on fee splitting, so giving a third party money, let's say for referrals and things like that. Consider that. Taxes we talked about a bit. I really do encourage people to talk to accountants early on to help understand what your tax responsibilities are going to be and to really help you pick the right entity for you based on, you know, what your practice is and where you live. Different places might have different taxes for different entities, New York City in particular. I'm going to come to that. And yeah, finally, consulting an experienced attorney as you move forward is important to get advice about your specific plans. So I have a few questions here that I want to get to. Just give me a second to read through. So the question is, I think, yeah, you're referencing the professional will, I think, and coverage in case something happens to an individual. So I think that there's a way for people to pick someone else in the community and maybe you each act as the other's professional executor. And in case something happens and you're there for each other, you keep each other posted when changes happen, make sure that they have a mechanism for, again, getting your like login information and things like that so they can access records, that you have, you know, alerted clients to this way of operating for this contingency. But it's hard. I see what you're saying too. Obviously, if there's a group practice, in theory, somebody else in the practice has access to all of the information in case something happens to one of the providers. But for a solo, I think identifying somebody else, it has to be a mental health professional as well, so they understand the rules and regulations around protecting client records, is really the starting point. I don't know if that answered your question. Feel free to tell me it didn't. I can try and expand on that. Someone asked if I have an accountant that I can recommend. I really wish that I did. I was hearing from clients, different agencies and individuals that they liked working with, which was so great because then I had, you know, a number of people giving referrals and I could share that with my other clients. And then I started to do that. And then all those accountants were full and not taking new clients. So unfortunately, right now, I don't have anyone to recommend for that. I would be curious if anybody else does, or maybe that's something that can happen on the listserv, and people can share good resources there, because that really is, it's such an important thing and very difficult to tap in. Although I will say, you know, tax day just passed. So in the next couple of weeks, months is really the time to get on that and work on them as their schedules hopefully have died down a bit. Okay, 2 people asked about the accountants. I'm sorry, I don't have better referrals for that. Will this recording be emailed to us? Thank you, Katie. And yeah, what else? What other things are people thinking about? This might be important for everyone to hear. Thank you, that's so nice. I'm really glad to have the time here today. I'm definitely happy to answer more questions. Again, people can feel free to reach out to me for more information about my services and fees. Okay, here is a really good question that could absolutely fill up the next 3 minutes about a dual relationship as an LMSW and a life coach. This is a really challenging thing around life coaching. I think generally the idea that I hear from people is that they're licensed in New York, and so they are going to operate under their license and, you know, provide psychotherapy services to clients in New York and do everything that's within their scope of practice here, and then potentially be a life coach in another state. That is a tricky road. I think you have to be aware of the rules and regulations of the other state. And, you know, if you're really just actually performing services that require a license in another state, but calling it life coaching, that is really not a workaround. Those other states are also requiring licenses for that work. So you can run into danger there for practicing a profession without being properly licensed. And that can be problematic. I think it also can be challenging for the industry in general and make it really difficult for consumers and potential clients to understand the difference and between a life coach and someone who, you know, has gone through all this education and training and supervision and hours of service to get a license so that they are properly qualified to provide psychotherapy services. Also keep in mind that you are licensed to perform these services. You can't just like step out of your licensure to do certain things. You're still held to that elevated higher level of responsibility, whether you're calling yourself, you know, the license that you have or not in that moment. I'm an attorney. I'm always an attorney when I give advice and counsel and do things, even if it's not required. Even if I don't need to be a lawyer to do those things, even if you do not need to be a licensed mental health professional to provide certain services to people, you're still held to that higher standard when you are performing those services. So please keep that in mind. Someone asked about, do I recommend doing a PLLC if you're using BetterHelp or other platforms? I do think that having a PLLC is an important part of engaging in these practices. I don't know the specifics about the contract between you and every different organization that's out there that's providing these services, but generally my idea or my understanding is that they are separate from you. They are not actually treating you as an employee. So you have your own liability concerns and they are not assuming responsibility for your practice. So I think creating that distinction is really important. I'm fine to go on a couple more minutes, Katie. I don't know if that's, I'll go maybe answer these 2 questions. Okay,
absolutely.
Cool. So thank you for this information. I read that one. I have a scope of practice question. Is this something I could ask you outside this workshop? Realize that was that. Yes, feel free to reach out to me. We can schedule a consultation. Oh, that's it. So we hit everything, I think. Great. Thank you for the time. Appreciate it very much. And thank you, Katie, for setting this up and helping.
Yeah, thank you so much, Dan, and thank all of you for attending this evening. Just a quick reminder that, again, this isn't a CE program, so there's no CE credits available for attending, but a recording will be uploaded to our YouTube channel within the next week or so, that you can watch at a later date. But again, thank you, Dan. Thank all of you for being here tonight, and I hope everyone has a great evening. Bye.